We're going to give you an answer to the proposed case study. Notice I said an answer, right? I'm giving you the answer that we went with, but that's the beautiful part about practicing law, is all the answers aren't the same. You probably could have come up with a different one, and at the end of the day, they probably would all work. So that's the best part of what we do. There isn't always one size fits all. There's a human nature element to everything, and obviously the client goals are the biggest part. So we'll tell you what we ended up doing in our solution for that fact pattern, and then we will adjourn. You're going to receive very shortly, as soon as we end, the evaluation for the day. For those of you who need credits, you have to fill it out. For those of you who don't need credits, we would beg you to fill it out to let us know how we did and how we could make it better. But if you need credits, you have to fill it out. We need you to return it to Cookie by 5 o'clock today. Yeah, well, you don't need the credits. Maybe you could let the credits go. I know, I don't get it. So please fill out, please fill out the evals. We do read everyone. We do make significant changes to these boot camps every time. There will be another one in a few months. I'm not sure of the location yet. We're kind of kicking that around. We think we might head back to York again, kind of rotate between the two back and forth. So we'll let you know when that comes out. But I do want to just say thank you all for coming and spending time with us and everybody on Zoom land. I hope you enjoyed the day. So Dan, take us home, my man.
Oh, that's right. Jeff makes me go last, so that if we're late, it's all my fault. So thank you, Jeff. I appreciate that one. We are going to go quickly through these last couple sections, folks, because most of the things we've touched on so far today are things within your control, right? They can change them. We can change our mind and opinions about these things. But once you pass away, a lot of those things are out of your control, all right? And that's going to be our focus now. What happens when somebody passes away? Now, the first thing that usually happens when somebody passes away is people feel the need to do things right away, all right? And it kind of blows my mind. I have people who call me before someone even passes away. You know, Dan, we're in the hospital. It could be any day now. I don't know what's going on. And I never mind talking to people. I never mind them feeling okay or helping in any way that I can, but there's really not much I can do. You know, you don't need to call your lawyer first when somebody passes away, guys. What you need to do is you need to grieve, quite honestly. You know, you always have time to do that. You need to pay attention to your family. That's what matters the most. And if you're the person who's in charge of that situation, you got to notify a lot of people, right? You have to notify other family members, and they could be all over the place nowadays. Employers, perhaps, right? Clergy members, people from the church who knew that person. The other things that come up when you pass away are basically two main issues: whether or not the person's going to be an organ donor and whether or not they need to do an autopsy, okay? We have a lot of useful information in the materials about both of those that I am going to go through quickly, guys, because it's more there for your benefit. I will tell you just generally, organ donation is an amazing thing, okay? It's life-giving things that you can do when you make organ donations. A lot of people think that as we age, we become useless in that capacity, but I talk to a lot of medical professionals who tell you that's not the case, okay? It's always a useful thing to do, and it can always benefit somebody else greatly, so definitely keep that in mind. Again, we have a few slides just showing how that process works, talking about how we make that designation. Of course, we can do it in a will, but we can also sign up to be an organ donor in other ways, right? We know we can do it on our driver's license, the most classic way, or you can do other documents that say that. At our firm, what we do is we include that designation right in your healthcare directive. Makes the most sense to us to put it there because that's what's going to be in effect when that time would come. There are ways to change or revoke that gift. Again, I'm going to breeze through those and let you read those at your own convenience. They're more for information purposes. It doesn't happen all that often. And when it comes to autopsies, look, there's basically only 5 different ways you can authorize an autopsy. It can be done by the person who died. They can write in an instrument that you give somebody the authority to do an autopsy on you, of course. That's easily done. It can be done by somebody else as long as they're the person who's in charge of the body at that point. It can also be done by the spouse. It can be done by a non-spouse if it's the closest living relative who's designated by statute. We're going to refer a couple times in this last couple sections here about the intestate succession statute. That's a statute in Pennsylvania that basically tells you who your closest living relative would be. It also comes into play if you die without a will. It says who would be in charge of that process and who would be receiving all of your assets upon death. Now that brings us to that topic, right? When somebody passes away, how do we get their assets to someone else? Well, remember, At the very beginning of my section, we talked about those non-probate versus probate assets, right? And what that really boils down to is whether or not somebody's going to go through their will, or the instruments that they're leaving to people are going to go through some other vehicle, right? Maybe a beneficiary designation. If a person dies with a will, their estate is what we call a testate estate. All right, it means we're going to follow the instructions in the will, and that will has to go through that process we talked about called probate, right? If you die without a will, Pennsylvania has one for you, okay? Like I'd mentioned, there's a statute that we call the intestate succession statute, and it answers those two basic questions we need to know. Who will be in charge of that process, and where is everything ultimately going to go? Now, whenever somebody does pass away, basically what we have to follow at that point is a timeline. That's what that probate process or trust administration is all centered around. A timeline that is focused on when inheritance tax has to be paid. So the first thing we need to be attentive of when somebody passes away is knowing that that date of death is important, because it's going to trigger certain dates with regard to that tax payment. Again, what you can do is within 90 days from the day somebody passes away, you can pay the estimated inheritance tax at that time. All right, that's important to do, because if you can meet that deadline, you're going to get a reduction in how much tax has to be paid. Obviously an important thing. So when you first open an estate, a lot of things happen quickly, okay? The first thing you have to do is you have to get the executors sworn in. They have to get their authority from a judge. So you have to, like Jeff said, typically go down to the courthouse, present the will and a petition to the Register of Wills. And if the will is valid, if it has the right witnesses, and the petition was filled out correctly, now they're going to swear in the executor. The executor has to take an oath, very simple one, just swearing they're going to obey Pennsylvania inheritance tax law. What do you think Pennsylvania is worried about with this process, guys? But once they have the executor sworn in, now and only now can somebody start acting on behalf of the decedent's assets. So what happens and what gets kind of nerve-wracking for folks is from the time somebody passes away until an executor is sworn in, nobody can access the decedent's assets, all right? Nobody can get there. Your financial power of attorney, that document dies when the decedent dies. And like I said, the executor can't take over until they're actually sworn in, which can take a little bit of time. But once the executor is sworn in, now we're off and running, okay? Now all kinds of things will happen. The executor is going to open up a bank account for the trust, and they now have to gather all the information, all right? They have to find out how much all these assets were worth, where they were, and what they are, and that can be tricky, okay? Sometimes you have to watch mail cycles, right? If you don't know what your parent had when they passed away, for example, if you never had that discussion, well, how are you going to find out, right? Hopefully you know the name of their financial advisor or their accountant. You start there, right? You look around at whatever documents you can find in the house, but even then you may be missing things. So like I said, it sometimes boils down to watching the mail come through for a few cycles just to see what's there. Now, when a spouse dies, okay, and the reason for this slide here is to show you the difference between when a first spouse dies and a second spouse. Now, like I told you earlier, when we're married, we typically own everything we can jointly. Or if we don't own it jointly, it's usually a retirement account, right? But that has a beneficiary designation on it, which we would always make our spouse first usually. The reason we do that is because we don't want to have to do anything from a legal perspective when the first spouse dies, all right? If everything was owned jointly or had a designation on it, we don't need to open an estate, okay? We don't need to use the will. Nothing's going to go through it. And that would be our preference for a surviving spouse because there's no inheritance tax due between spouses. It's a 0% rate. So really nothing has to happen from a legal perspective if we have that set up correctly. But when a second spouse dies, at that point, everything they owned is usually individually owned property, right? That's when we have to open an estate, hire a lawyer to help you through that process, and go through that probate process we've talked about. Now, a few things can happen when people pass away that you need to be aware of, right? They could be divorced, or maybe we think they were divorced. You have to make sure it was official, there was a divorce decree, because that can be important. For example, if you forget to change the beneficiary designation on your IRA from being your ex-spouse, well, if you can show a divorce decree, there's a presumption in Pennsylvania that you meant to change that, and you didn't just forget, right? So that can be very important. We also need to look at children, okay? A lot of times when you're the second spouse to die, if there's family, it's going to be the children who are in line to inherit, right, under the will or even under that statute. But at that point, we need to look at the condition of those children. Are they available? Can we find them? Are any of them predeceased? Maybe they died before their parents. Do they have disabilities, right? We've talked about all these issues. When you do a good will, the kind of wills that we do at our firm, they're very comprehensive. Most wills account for what happens in all these scenarios, but you have to be aware that it's going to be an issue, and you want to spot that early on in that process. Now again, what we do in that probate process initially is we have to find out what assets are there. And when we're handling an estate, there are 3 different types of assets that we deal with. The first category of assets is what I would call your stuff, all right? We call it your tangible personal property. That means things we can touch, literally. So your clothing, your personal items, your vehicles, okay? These are things that are valuable to you because they're your things, but not usually valuable to any other person. Or the same way my things are valuable to me, but not to any of you, right? So we're usually pretty general with those instructions. We usually say, look, we're going to leave those all to our spouse if they're still alive, and if they're not alive, we're going to let our kids divide that up as evenly and fairly as they can, and what they don't want, they can either donate or sell, and it just becomes part of the estate. The second category of property that we cover is real property, self-explanatory, right? Our real estate. And the third category is everything else, right? Our financial assets, any other bank accounts, things of that nature. Those are the 3 categories of property that we always deal with when we're handling an estate. Now, like I'd mentioned, dates become important, right? Because we have these deadlines. As I'd mentioned, we try to prepay that tax 90 days after the date of death so we get that tax reduction. But 9 months after the date of death, now the inheritance tax return is due. So what we're doing in between those 2 dates is trying to verify all that information. And you would think in this day and age that's pretty simple, right? For example, if I have a bank account at a bank, well, I on my phone can pull up a website right now and tell you exactly what's in there, right, this afternoon. So why couldn't I just do that? Figure out what day the person died, right? See what it is? It's actually not that simple. What you have to do is you have to work with each institution and have them issue what's called a date of death value letter. They do an internal assessment. You have to present things like a short certificate to get this information. And you have to wait for a third party to give that to you. And that's why this becomes a frustrating process, all right? You're dealing with a lot of third parties at that point, and no offense, but they're not as worried about it as you are, right? So it can take time. You have to pester them. This is why people hate this process, okay? Because it slows down and it grinds to a halt about halfway through. But ultimately, we do get that information. We pass it on to the people that need it, and we can fill out the tax return and get the tax paid on time. Now, again, we've mentioned about what probate is, right? There really is no formal definition. It's just the process we have to go through, okay, to carry out the instructions in a will. Technically, the original probate of the will is when you present it to the Register of Wills to see if it's valid. All right, but that's really just the first step in a very long process that can take almost 2 years typically. So that's all that probate really is just a name that we use to call that overall process generally. Now, wills have to be valid in order to be processed, okay? There's obviously certain requirements that go along with that. It has to be something that's written down, again. There has to be the intent to make it. The person has to have capacity. Nothing that would really shock you. But one important thing here in Pennsylvania that you want to do is you want to make sure that your will is self-proving, okay? That just means it was witnessed by 2 people who swear at that time in front of a notary that their name is correct. They've witnessed what you've seen. If it's not a self-proving will, it can still be used. It's just a little bit harder to get that validated by the court. So that's why any will you do should always have those 2 signatures and have 2 witnesses for each one. Now, short certificates I've mentioned. A short certificate is something that is given to the executor, and it's kind of like their golden ticket, right? Remember Willy Wonka? You had to get the golden ticket to get inside. A short certificate is what the executor has to present to financial institutions to get information. Okay, that's what proves they're the executor. They're issued by the court. That's why they're so important. Now, we also do advertising when we open an estate, and some people find that strange. Okay, they don't really understand why we have to advertise that an estate's been opened. And it has to do with a liability issue, okay? An executor is personally liable if a mistake is made during the estate process. All right, if they make a mistake, they're the ones who are holding the bag for that liability. But what they can do is they can start a statute of limitations on how long they're exposed to that liability. From the time they put that advertisement out there, anyone who wants to bring a claim against the estate has 1 year to do so. And if they don't do it within that 1 year, that statute of limitations tolls, and that ends their liability. The fact that the executor is personally liable is also another reason that most people hire law firms to do this for them, okay? It's not that estate work is impossible to do if you're not a lawyer. It is complicated though, all right? And there's a lot of steps that you have to take. And like I said, if you make a mistake, you can be personally liable for that. Whereas if you hire a law firm like us to do that for you, we take on that liability in your place. It's another important reason to do that. Now, again, there are other deadlines we follow. We have to send notices to beneficiaries within certain deadlines. We mentioned the inheritance tax return is due 9 months from the date of death. And that 9-month date can be a little bit deceiving because most people think that's when the process is over, right? When you pay the tax. But it's not, all right? It has to get approved by the state. That's the problem. So when we send these tax returns in to get approved by the Department of Revenue, before the pandemic, we were waiting 3 to 6 months. When the pandemic hit, we started waiting 9 to 12, and we're still waiting about a year to get approval from these things. So as you can see, you take about 9 months to a year to get to where you know what's going to happen, and then it can take another year until you get approval by the Department of Revenue on that tax return. That's why it takes so long. Uh-oh. I've lost my ability to click. That's not good. Working? Okay, all right, well, now we got it fixed. Now, let me see where I went past here. Not working on me again. Boy, oh boy. Now, here we go. Now, basically, the way we end that estate administration process is one of two ways, all right? You can either go to court and show the court, the judge, what you've done and have the judge approve it and say, yes, you've done an effective job, it's over. Or the more common way that we do it is by just doing a family agreement, all right? The family agreement is essentially a waiver, right? It's the same way any case would close in a lawsuit, for example. You have all the interested parties sit down, look at what was done. If they all agree that it was done correctly, they can sign what's essentially a waiver, and that just says we're going to hold the executor not liable anymore because we agree it was done correctly, and that will end the process at that point.
That process different in different states?
It can be different in different states, very different in different states. For example, Pennsylvania can be hard for this reason, all right? If you die owning anything in your name alone that's worth more than 10 grand, you only can get it to somebody else by opening an estate. There's no exceptions, believe it or not. Other states, they have higher limits, right? So that we don't have to spend all that money to go through small estates. It's just expensive. You know, our firm, we have a minimum fee that we charge. It's not unlike any other firm. It's about $3,500 just to open an estate from a minimum level because whether we're passing $10 through it or $10 million through it, thank you. There's a lot of work that goes into that. So that's the unfortunate reality here in Pennsylvania is that there just aren't a lot of ways to get around it if you have that problem. Now, if you have a trust, and we mentioned this a few times as well, remember, a trust doesn't go through the probate process. Only things that you own in your name alone have to do that. But if you die owning a trust, the trust has to go through a similar process that we call trust administration. There are minor differences to this, folks. There's a little bit different notice requirement. You don't have to notify as many people, and it's not a public process. That's what some people like about it, all right? It keeps your information private. Nobody can find that out. But it really isn't quicker, and it isn't much less expensive, all right? You still have the same deadlines with the tax return, folks. That's what it's all centered around. So you're still waiting the same amount of time. And like I said, it could be a little less expensive from a legal perspective, but here's how it is with us. Not unlike most people, right? We charge usually around 3 to 4% for non-probate assets, or excuse me, for probate assets, 2% for non-probate assets. Not much of a difference, all right? You're still going to go through a process either way. Now, we have mentioned inheritance tax several times, but just to reiterate that, we have inheritance tax where we tax from the first dollar here in Pennsylvania, but thankfully our inheritance tax rates aren't that terrible, okay? 0% rate to spouses. Notice I didn't say no tax. 0% rate. Please hope it stays that way, all right? It's 4.5% to our lineal descendants. So your kids, grandkids are back up to your parents, all 4.5%. 12% to your siblings. 15% to anyone else in the world, including your beautiful nieces and nephews, all right? So again, it's an unfortunate thing, but there's only one way to avoid inheritance tax in Pennsylvania. Give things away at least 1 year before you die. I guess you just write that date down on a calendar and work backwards. Not real sure how that works, but you know.
What about charities?
Charities, 0%. Charities, you can also give away 0%. Yep, absolutely, yep. Okay. Again, there is a federal estate tax, guys, but most of us don't have to worry about it because it only applies to assets in excess of $12,060,000. So for most of us, we don't have that problem. And again, you can contest a will, all right? The easiest way to try, well, there's no easy way to contest a will, but the most common way would be to try and say that the person was under duress when they signed it, right, or lacked capacity. Jeff touched on the capacity standards, right? It's a surprisingly low bar, okay? So if you're going to try and challenge somebody's capacity to sign a will, good luck, because they don't need much capacity to do it in the first place, right? They just have to have a basic understanding of the natural objects of their bounty. Well, yeah, I have 3 kids. And they have to generally know what they have. Well, I have a house and 2 bank accounts. And they have to know where they want it to go. I want it all to go evenly to my kids when I die, right? Pretty low standard. Undue influence or duress, conversely, is a very high standard you have to prove, okay? If you're going to try and prove that somebody signed a will or any contract, quite frankly, under duress, Pennsylvania has a very high standard for what they think is duress. It almost boils down to where somebody has to be holding a gun to your head and you're going to lose your life unless you sign that piece of paper. So again, you can contest a will, you can try, but the odds of being successful are pretty low. All right, we talked about undue influence. That's going to take us pretty much to digital assets. I want to make sure we save time at the end to debrief and talk about the hypotheticals. So we're getting pretty close to it. Do you want to mention a few things about digital assets, then we'll get into the debrief? Jeff is our resident digital asset expert. So he's going to take the last section here, and then we'll get ready to debrief.
All right, I think... Are you there now? All right. All right, good. We're not going to spend too much time on this, to be completely honest. The biggest thing here is you want in the power of attorney for there to be language specifically for digital assets, which we do have in our documents. That way somebody has authority to be able to get access to all of the different accounts whenever a person passes away. Obviously, giving out the account numbers during life could have a pitfall, right? Depending on whether you trust the person you're giving them to. So in our opinion, let's give them access through the POA if you become incapacitated and through the estate planning language if you end up passing away, so that we don't have to be giving away passwords during a lifetime. Obviously, there are criminal charges that can be sanctioned if a company exceeds their authority or does something that they're not supposed to be doing and obtains financial records. I think we see a lot of that going on, or have seen a lot of it, so I think there's going to be a lot more of that to come. We did have a statute in Pennsylvania finally got codified recently called RUFIDA, which is coming up. Yeah, there it is. The Digital Uniform Fiduciary Access. 42 states have adopted it. Pennsylvania is now they did adopt it, so we do have to change this slide. At least now we have that in our state as well. Authorized personal representatives, guardians, agents of powers of attorney, and trustees do have access to digital records, but they cannot exceed that access and receive information that they're not supposed to. And I love this slide. What is it that we're doing every 60 seconds? So for those of you who cannot see it, there are 200,000 people tweeting, 2 million swipes on Tinder, 69 million messages sent, 28,000 subscribers watching Netflix, 1.4 million people scrolling on Facebook. Are you kidding me? It's just fascinating. And that was a year ago. I bet you it's a lot worse this year. Again, same thing. We recommend that you keep your information private until it's needed. We'll be able to do that through the POA language and through the will. So, the case study. Remember that thing from the very beginning earlier today? So what I'm going to do for the sake of kind of ending the day on time, I'm going to read to you what we did. Hopefully, as we were going through the day, we're able to kind of think about, ooh, there's an issue. Ooh, there's an issue. What we did was Jane bought the house from John for $90,000. John set up a special needs trust for Roger and funded it with $147,000. John and Jane each bought an irrevocable burial reserve for $10,000. John's car was sold to pay for the irrevocable burial reserve. Jane buys the annuity for $147,000, paying $800 per month for life. Jane spends $5,000 on a new furnace. We got to replace that furnace. The couple split the cost of the spend down limits, $14,000. So, at the end of the day, the total marital assets were $354,600. What benefited the wife? $147,000. What benefited the grandchild on behalf of the husband? $147,000. The total spend down amount was $14,000. Sounds like we honored the prenup, right? Everything was split exactly 50-50, which is what we were hoping for. Did we address Jane's monthly budget needs? Yep. Did the prenup get honored? Yes. Did the husband have capacity? He did in real life. I didn't give you enough in the facts to know that, but he did in our case, in the real life case. The status of the 84 will, well, as soon as it was ripped up, what happens? It became destructed, right? It goes away. It's null and void. But also the divorce would also exclude the husband. So the divorce would have done that as well. Did we protect Jane's assets in the future? One thing we did is we excluded the husband in the will to make sure. Veterans benefits, we did use a qualifying trust, which these days would be a little harder for all the reasons that we told you earlier, but we were able to in this case. And what happens if John ends up in end-stage medical? If he doesn't have capacity, the wife and John's daughters will have to agree. If he did have capacity, he could enter into an advanced healthcare directive. So we always say, one of the jokes we always make is, there is a healthcare statute, and don't worry, your spouse and your kids from a previous relationship will hold hands and sing Kumbaya. Let's hope. So anyway, thank you so much for coming today. Thank you for those of you who attended on Zoom. The people at home already received their email. The people in the room will be getting their email any minute for the evaluation. Please fill out the eval, return it to Cookie by 5 o'clock today if you need credits. If not, you can take your time and get it back. But we really do encourage you to return it because we do read every one. Yes, sir. They will be any minute. They were emailed to the people on Zoom. They will be emailed to the people in the room any minute now. That's fine. Just return it. Yeah, there's not a hard number. We just don't want everybody waiting, that's all. All right. Thank you guys very much. We had a wonderful time.